Okay. So, before I introduce our final speaker, I just want to again thank our sponsors and especially all our panelists throughout the day and attendees both present and online for being here with us. I think it's been a bunch of great discussions. We're privileged to hear as our final speaker, Professor Scott Hemphill. Scott is the Moses H. Grossman Professor of Law and co-director of the Engelberg Center on Innovation Law and Policy, NYU Law. We were just talking about how amazing that center there is at NYU Law. He teaches and writes about antitrust and intellectual property. His research focuses on the law and economics of competition and innovation. He's written like scholarship ranges from drug patents to digital platforms, the use of trademark law, the thwart competition. And his recent work examines the anti-competitive acquisition of startups, which we've heard a bit about today throughout the panels by dominant firms in the technology sector, and probes how institutional investors might weaken competition among their portfolio companies. His work is published in top law journals, been widely cited by the US Supreme Court and other courts, and has also appeared in peer-reviewed journals of economics, science, and law. He's testified before Congress about antitrust issues. And so we're thrilled to have you here and look forward to your comments. Thank you.
So thanks to Clark and the organizers for the opportunity to join this outstanding group. It's a challenge to be the final speaker after such a rich discussion, but let me try. Today I want to offer a few thoughts about the current state of tech platform competition with a particular focus on online retail, drawing in part on some of what we've heard earlier today. Now, when it comes to platforms, our goal as competition analysts and policymakers is to try to figure out how best to preserve and nurture competition. And so in the next few minutes, I want to think a little bit about how that plays out as to three different modes of competition pertinent to platforms. Competition first against the incumbent platform in its core business, competition by the platform in adjacent businesses, and competition on the platform as undertaken by platform users. Now, the first kind, competition against the incumbent platform, I guess is the most familiar, right? For example, a search engine such as, I don't know, DuckDuckGo is a competitor to Google in search. Here, one theme that I'll spend a little bit of time on is that we should be working to protect nascent competition, this emergent, potent, possible competition, even when the likelihood of successful entry by that nascent competitor might be highly uncertain or even known to be relatively low. Second, the second kind of competition is competition by the platform, or if you prefer, competition between or among platforms. So for example, Google is a challenger to Apple in smartphones or to Amazon in shopping starts. And here I want to emphasize the role of what I'll call disruptive incumbents in introducing competition in adjacent industry segments. And one upshot of this discussion will be that sometimes we ought to have a light touch in antitrust enforcement against a platform in order to give some running room for these giants to take one another on. Finally, third type of competition that I want to talk about is competition on the platform among users. So for example, Google's keyword-based advertising platform facilitates important competition among firms. And these benefits are currently being eroded by anti-competitive collusion among platform users. And my message here is going to be that ending this practice should be a priority for enforcers and a source of real concern for courts. Now, much of what I have to say here is based on some recent academic work. I have a paper about nascent competitors with Tim Wu in the University of Pennsylvania Law Review. There's some work about disruptive incumbents recently published in the Columbia Law Review, and finally a paper on this problem of anti-competitive collusion among online advertisers that's co-authored with Eric Hovenkamp, that's forthcoming in the Antitrust Law Journal. Before launching any further into substance, by way of disclosure, I've consulted on platform competition issues for the government and for private parties. I'm doing work with the plaintiff states. Phil Weiser was name checked earlier, so involved on the plaintiff side in the Colorado versus Google litigation. Today I speak only for myself. Okay, so to start with this, I think, relatively familiar idea of competition against the incumbent platform. This is the realm of exclusionary contracts and self-preferencing. We've heard a lot about this today. Obviously, there's a major focus of enforcement and scholarship. Makes sense. There's a lot to talk about that's going on right now. Now, one reason for this concern is that a powerful platform often has an outsized ability to thwart new entry. And it may well be, as we heard earlier, be willing to invest in that exclusion because there's so much profit to protect. Now, there's another reason for concern, which is that the innovation lost as a result of exclusion can be quite significant. This is an old idea. It's frequently noted that incumbents are often reluctant to cannibalize their home markets. For those of us who do competition economics and policy, Ken Arrow looms large, as he showed an incumbent's incentive to innovate can be lessened by a so-called replacement effect. The name comes from the fact that the resulting innovation, if achieved, would replace existing profitable sales. And this replacement effect suggests that innovations might be more likely to come sort of by process of elimination, more likely to come from an outsider with no existing sales to replace. Now, this replacement effect is one reason to look to outsiders for innovation and to be especially worried or concerned when their entry is thwarted. Coming to the means of exclusion, it's often said, famously by the Microsoft court, the means of exclusion are myriad. It could take the form of coercion of customers or suppliers, thereby weakening their relationship with the targeted rival. We see an alleged example of this in the context of online retail and Amazon's alleged use of most favored nation type contracts with third-party merchants. An incumbent might use carrots instead of sticks, or in conjunction with sticks, to induce the cooperation of customers or suppliers. And of course, still another option is to go directly to the source by acquiring the threat. Now, in all of these situations, we're worried about the loss, the removal of an independent competitor. Now, this resulting exclusion is a concern when the outsider represents a serious future threat to an incumbent. Now, I want to emphasize this. This is true even if the competitive harm is quite uncertain, or even if it's low probability. Now, this kind of situation is not a merely academic concern. It's often the case that the firm that poses a uniquely potent threat to the entrenched incumbent is a merely nascent competitor. We don't know yet what's going to happen. The potency is not yet fully developed or established or much less proven. Its eventual significance might be highly uncertain. And this might be especially true in environments of rapid technological change in which these nascent threats tend to arise. So what are we supposed to do in this situation? Right? This is an area of active debate. From my perspective, it's intuitive or even obvious that a 20%, let's imagine, a 20% chance of $1 billion consumer harm is something we ought to avoid if we can. Tim and I get into some detail about this in the piece. Avoiding a harm with a large expected value, in my toy example, $200 million, is a valid and pressing goal for antitrust enforcement. And if we ignore these kinds of harms, effectively discounting low probability harms to zero, we're going to be permitting some serious anti-competitive harm to slip through the cracks. So let me turn now to sort of topic number 2, the second mode of platform competition, namely competition by the platform. Now, my main theme here, as I mentioned, is that it's important to recognize, to harness when we can, platforms themselves as a source of new competition. In other words, we need to understand these disruptive incumbents in order to harness them. What I have in mind is situations where one of these big tech platforms offers important new entry in an adjacent business. So to come back to Google, Google has challenged Apple and smartphones with Android, Amazon and shopping starts with various product offerings, including Google Shopping, Facebook in personal social networking services, Microsoft in productivity and operating system software. That's just Google's forays outward. Everyone probably has favorite examples of their big tech firms. This push into adjacent markets keeps other firms on their toes. Coming back to Arrow for a minute, it provides a fresh lens through which we can understand what for academics is a long-standing debate between the acolytes of Ken Arrow, who I mentioned before, and those of Joseph Schumpeter, about whether it's monopoly or competition that best promotes innovation. Now, it will be familiar to a lot of the folks in the audience. Schumpeter kind of takes the view that there's a positive association, or his work stands for this proposition, that there's a positive association between innovation and incumbency, in potential contrast to the Arrow replacement effect that I was talking about a minute ago. Now, one version of Schumpeter is the idea that the prospect, ex ante, the prospect of acquiring market power elicits innovation. Now, this version, what an antitrust might call kind of the Trinko version of Schumpeter, is actually consistent with Arrow. That is, it could easily be true that the prospect, right, the prospect of monopoly induces innovation ex ante, like Schumpeter would say, but then later the firm gets lazy or hamstrung due to this replacement effect idea. So Schumpeter ex ante, Arrow ex post. But there's another version of Schumpeter which puts the conflict more directly. The conflictual version is that monopoly, even ex post, is itself a potent platform for further innovation. It confers a special capacity to innovate or incentive to innovate. Now, their battle is really joined. But even so, there's an important and I think neglected point of reconciliation between this Arrow view and the Schumpeter view, that they coincide, or at least consistent in their attitude toward innovative efforts outside the home market of the incumbent. I mean, Arrow's point, after all, is about cannibalization of the home market, that the incentive to innovate would be diminished. But it presumably remains undiminished in these other markets, other businesses. Schumpeter, on the other hand, is interested in the ex post kind of capacity and incentive to innovate. So as long as we're thinking about kind of adjacent markets, one might well expect Schumpeter and Arrow to agree that there's something interesting for us to try to celebrate or hold on to or protect. And there are various forces that favor disruption by the incumbent. Platform might be particularly well positioned to enter a next door market. It might also prefer to have a lot of competition in that adjacent market, right? Just think of a content provider eyeing distribution monopolies and thinking, gosh, it'd be really great if there were a lot of distribution outlets. Maybe I can seed a higher degree of competition there and thereby weaken gatekeeper status in other parts of some kind of stack. Now, of course, at the same time, there are forces tugging the other direction, these usual forces of inertia and détente take the form of a kind of tacit collusion. And as a practical matter, and as a legal matter, perhaps, it's difficult to force firms to compete if they prefer each to sit tight. And so we need to be thoughtful as analysts, as enforcers, about how to keep this competition among giants going as robustly as possible, rather than letting things kind of slip into détente. Now, I think this is a major challenge for us to be thinking about as scholars and as enforcers. How do we encourage the competition, and how do we minimize the détente? I'm not really sure how we accomplish this, though I think one piece of the puzzle is that antitrust enforcers should consider a lighter touch toward enforcement on the margin in situations where a firm is, if you will, sort of punching up to compete with another platform. So Google and shopping is the example that comes most readily to my mind. If Google is presenting shopping results in a particular manner, perhaps let's grant for a minute, a legally contestable manner, in order to better compete with Amazon, we might want to give some running room to that, given that Google might be one of a handful of entities capable of actually engaging that kind of competition. This could be a reason to be skeptical of the European Commission's choice of shopping, now many years ago. Among all the search verticals they might have brought a case in, when it launched its initial competition law attack against Google's search business. Finally, let me turn to a third form of competition. This is competition on the platform. I mean, obviously, platforms are sometimes good for competition. One, because they provide this fresh entry in adjacent businesses that I already mentioned, but also because they facilitate competition by providing tools to business users to compete more effectively. So computing power and storage, I guess, is the obvious example we often think about. Cloud computing has enabled a great deal of innovation by other firms. So take Dropbox, right, the leading file storage firm. For a lot of its existence, it relied on Amazon Web Services to do the actual file storage. Another example, coming more directly into the business of online retail, which is the theme for today, is competitive advertising. So to take what will clearly become a non-random example, take the example of selling contact lenses online. Walgreens sells contact lenses, and Walgreens, among others, does so in competition with 1-800-CONTACTS, the leading online purveyor of contact lenses. And until recently, buying advertisements on Google was a significant element of Walgreens' marketing plan. These ads, people are familiar with search ads, I expect, but just to be clear, these ads appeared alongside Google search results above or below when a user searched for, I don't know, online contact lenses or AccuView, or as relevant here, 1-800-CONTACTS. Right? These ads target likely customers and inform them about Walgreens' business. Now, search ads, and in particular, search ads targeting a competitor, i.e. pop up when my rival is being searched for, are a potent and cost-effective way to advertise low prices and other attractive features. Now, this kind of competition is moreover of rising importance as online retail gradually supplants traditional brick and mortar, and more broadly as everyday activities continue to migrate online. Now, 1-800-CONTACTS had a response here. They did two things in response. One, they filed trademark suits against competitors, because 1-800-CONTACTS is a trademark, and so keying your ads to 1-800-CONTACTS was regarded, arguably, by the company as a trademark infringement. They allege that these ads are confusing and thereby infringe the trademark. Now, this litigation, by and large, did not go to conclusion. The one case like this that went to conclusion came out against 1-800-CONTACTS. Instead, they settled the litigation, and the two firms agreed not to run ads triggered by one another's firm names. And so now consumers who use Google to reach 1-800 are kind of left in the dark about the better deal offered by Walgreens or other competitors with whom there is a settlement. If those who are on phones type in 1-800-CONTACTS, you may get a competitor to show up. Not everybody is settled. Last I checked, Warby Parker, for example, is engaged in litigation with 1-800. Similar settlements have been reached in a wide range of other industries, airlines, hotels, credit cards. We're seeing this elsewhere in the economy. Now, without the trademark angle, I think this would be a pretty straightforward antitrust violation, right? A mutual agreement to disarm and not to compete along some dimension. The trademark suit provides a basis for arguing that the settlement is merely vindicating trademark interests, raising the question, how do we reconcile antitrust with trademark? And so in the paper with Eric that I mentioned, we try to offer a framework for how to think about trademark settlements that draws upon what is in some ways an analogous question about patent settlements. So for those who think, gosh, I think there was that Supreme Court case, Activist, turns out Activist is of some relevance for thinking about this problem. And we identify some settings, in which the trademark-based defense simply wouldn't apply. So Imagine this settlement restricted competition even beyond what you could get, even if you won your trademark case. Right? That kind of overbreadth is a sign, it's a tell that the settlement is anti-competitive and that it can't be defended, at least on trademark policy grounds. Other settlements involve a kind of reciprocal avoidance of competition by both firms, right? I won't compete with you in exchange for which you don't compete with me. The mutual agreement by Walgreens and 1-800 might be an example of that, suggesting that each is compensating the other for forbearance. And so that situation is one that we think is ripe for condemnation as well. Now here, the message, I guess, to enforcers is that more action is needed. The FTC brought a case a few years ago. I picked 1-800 Contacts because they were the defendant in that case. They won until they got to the Second Circuit. The Second Circuit ultimately rejected the antitrust case in what I think can only be described as a highly problematic and disappointing opinion. I mean, you know, for those who are interested in this area, go read the opinion and see what you make of it. Or read my paper with Eric and we can give you a view of why we think the Second Circuit got it so badly wrong. There hasn't been, so far as I know, further action by the FTC. Not sure why. Two possibilities occur to me. One, the enforcers might be gun shy after this defeat in the Second Circuit. Second, one of the victims here, of course, is Google, is the search engine, right? The folks who get paid for the advertising get paid less in an environment of collusion. And so perhaps it seems like a poor use of resources relative to the large number of other things an agency could be doing. For my money, my suggestion here was that this is an important area. And we're getting some really bad law from the Second Circuit, and we should take another shot at this, that enforcers should overcome hesitation and explore bringing another case. Let me take just another minute or two in terms of wrapping up. You know, I've been talking about these different three modes of platform competition and how we might go about preserving it. But I guess I want to close by acknowledging the limits of the antitrust lens. Now, for those of us who follow this area, we've heard about a lot of different harms that could be committed by a platform, not all of which have an antitrust solution. And I want to close by just thinking for a minute about the recent complaints that platforms kind of copy innovators' products and marketing decisions of smaller rivals. So, you know, Amazon, I think, has been the major target of this. That Amazon has kind of a knack for spotting profitable products sold on Amazon.com, Duracell batteries, let's say, is a common example, and introduce their own version. Now, antitrust's first response here might well be, well, so what, right? Private label goods are a familiar sight in supermarkets. The copyist strategy does not depend on weakening the copied firm. Often copying supports competition and lower prices. And so in a lot of situations, copying is not of much interest to antitrust. Now, I think it has to be acknowledged that platform copying can easily be more complex than my supermarket example. Platform may be participating in multiple related businesses, might have an informational advantage at the center of some complex web of sellers and customers. For me, what this comes down to is the empirics that I think haven't yet really been established. It seems to me that in principle, platform appropriation might be so rapid and systematic and effective as to truly discourage certain kinds of innovations. Is that happening or not, right? Is a marketplace seller deterred, in fact, from investing in product discovery lest Amazon come in and appropriate the benefits? I mean, in principle, it's possible, right? But in practice, how much is this happening? You know, how broad-based is it? To what degree is it really undercutting innovation? As opposed to, you know, surely limiting rewards, but really causing innovation not to happen that would otherwise happen. Strikes me that a demonstrated problem might justify targeted relief, not as a matter of antitrust policy, but as a matter of innovation policy. But I think this is a question for the future. I don't think that this is, as far as I know, really been established in a broad way. So Thanks once again for the opportunity to share these thoughts with such a terrific group, and I look forward to any questions you might have. If you hadn't asked a question, I would have been disappointed. So I appreciate it already.
I hope my question doesn't suggest I missed anything of what you said. You know, I think I have. It's a little off point, but you know, the agency's focus on nascent competition is sort of derived from. At least the standard they might like to apply is sort of derived from Microsoft, I think, at least when I was there. And I'm wondering what you think of ways to make the framework in Microsoft sort of a useful framework for litigating or trying or framing Section 2 cases, you know, in the, well, generally, right? I mean, the previous panel, and you were here, they talked about sort of the conduct specific standards for predatory pricing and discounting and the like. But then, of course, mentioned that there's this general rule of reason approach articulated in Microsoft. But that really has not been developed in the Section 2 case law. And, you know, one of the things we were trying to do in OPP at the commission was just sort of think about both the process and substance of making that, I'll call it, you know, a useful framework for getting around some of the hurdles of Section 2 case law. Doug, you know, I'm going to stop in just a second. I've talked about this with, you know, Doug Ginsburg, who was at least the primary, if not sole author of that opinion. And and what I took from that conversation was, you know, it was a good idea, but it really hasn't panned out. So, you know, this is a question academics can noodle on with limited opportunity cost. So I wonder if you have any thoughts on that.
Keep bearing in mind at all times my limited opportunity costs. Let me try a little bit. I mean, my initial reaction is that Microsoft is highly relevant and helpful as a framing device for thinking about what's going on here. And it's something that, you know, Tim and I get into in the paper a little bit, not exactly in the way that the point of your question really is, but let me back into that a little bit. You know, I think one of the core contributions of the Microsoft framing is to make clear that one needn't establish that the success of the threat is highly probable, right? That reasonably capable of making a significant contribution to the maintenance of monopoly power is what we're looking toward as our kind of North Star. And one can take that idea about causation seriously, whether or not you think the rule of reason, like order of battle that's done earlier in the opinion, is the right one. To my thinking, that core insight, an insight that, by the way, is shared in other cases like the Supreme Court's opinion in Activist, which is also about the loss of merely probabilistic competition, carries over across the full range of Section 2 cases. Now, coming closer to what you're really interested in, it's absolutely true that Section 2 doctrine is a mess to the extent that we have cross-cutting pronouncements. Microsoft is a cross-cutting pronouncement. Grinnell is a cross-cutting pronouncement. And at the same time, we have our little silos about, okay, what's exclusive dealing going to look like? And what's predatory pricing going to look like? Worse, when we get to predatory pricing cases that are apparently Section 2 cases, a court may or may not even mention that, by the way, we're embedded in a larger Section 2 case. And so, I could have a predatory pricing case where I'm asked to demonstrate price below cost and likelihood of recoupment. And wait a minute, this was a Section 2 case. Was I supposed to also show monopoly power? The court may or may not fasten on to that. Now, to some degree, this may be a question of advocacy and parties for their own reasons offering their own view about what the right doctrine is. I think the overall procedure about showing anti-competitive effect and offering evidence about pro-competitive justifications is helpful. In some ways, it's, I don't know, almost derivable from first principles. But how to stitch together these general cross-cutting commands of the courts, whether it's Microsoft or whether it's Grinnell, and the more specific silos, I agree is a hard and not fully resolved question. I have a new colleague at NYU, Daniel Francis, with whom you might have overlapped at FTC, with whom you might have had conversations on this topic even, who has a terrific paper either just out or about to be out in Antitrust Law Journal, trying to make sense of this kind of perennial question about how we should think about Section 2. The problem, I should say, is compounded by the fact that we think of Section 2 as being a distinct body of law from Section 7 of the Clayton Act. To me, Section 7 of the Clayton Act, particularly as interpreted by some lower courts, has gone a little bit off the rails in its suspicion, in its hostility to actual potential competition claims. And so we have some dissonance between what might be happening in Section 7 and what we think ought to be happening in Section 2, which in some ways makes the problem that you're talking about even a little bit worse.
So in the sort of Arrow versus Schumpeter thing, which people have, Carl Shapiro has, and Carl and Fiona, and somebody from Europe has one. So in other, so the idea that like having some kind of monopoly profit as an incentive to invest in stuff, that goes all the way back hundreds of years. That's why patents are in the Constitution and everything. But in other areas, like there is short of a consensus, but like there's a lot of people who think IP is too strong. And not just because of like static harm versus dynamic, that monopoly has static harm and dynamic benefits, but it has dynamic harm because innovation is also an input into the next innovation and so on. And that is, a pretty widely held view in the IT world. I wrote something not too long ago that a similar point could be applied to labor non-competes. But there's a similar argument that there'll be some sort of information sharing or something, and that maybe non-competes. There's a bunch of empirical evidence by Evan Starr and others that show that non-competes are bad, and maybe one of the reasons why he's finding that they're bad is for a similar reason. So if you believe any version of that, how much do you think? You could probably guess what I think, but how much do you think that applies to antitrust when we are doing whatever Arrow versus Schumpeter balancing that we're doing? Should we be worried, or should we think that maybe that like value of monopoly as an incentive or the promise of monopoly profits as an incentive to invest might just be obviously has some validity, but it might just be overblown.
Right. Yes. I I take the force of the point to be that the usual, as if I restate, the usual simple-minded, correct, but simple-minded idea about there being a trade-off between, static benefit and dynamic harm, or the opposite, static harm, dynamic benefit, is complicated by the fact that these nuggets of innovation are themselves inputs, and so you could get in the way of follow-on innovation. I think on the margin, the context in which that matters ought to lead us to feel even more strongly that there's something real about that innovation at the edges intuition that a lot of people have, right? I think that it would be a gloss that leans you toward the Arrow camp against the Schumpeter camp, right? Once you add this bit in. The salience or the the real world heft of the point is surely going to vary by context, right? In brand versus generic competition, how worried are we about the innovator, if the patent in question is on a genus rather than a species, having the effect of disabling differentiated competition within a therapeutic class. Now, this particular example, I think, is kind of a fake example, because when it really comes down to it, often the courts say, you get a patent, and you get a patent, and you get a patent. And so each of the innovators have space to do their own differentiated, I don't know, SSRI or something. So we also have the additional complication of IP policy, or IP policy makers sometimes quietly undercutting what our intuitions might be, even about what IP is actually doing. So I think the answer has to be super context specific about whether that additional complication that I think you're right in raising turns out to really matter in practice.
Okay, so I have a question that's actually related. It's on the second kind of point you made about competition by the platforms. And I have not read your piece on the Columbia Law Review, but you made me want to read it.
Mission accomplished, great.
But I guess my question is, and maybe you answered in part now, what is the baseline context? Because somehow, if we want to be lenient towards that kind of competition, we're somehow assuming that the only kind of competition that can emerge in that space is the competition between big tech players. But if we take, say, the spirit or the goals of something like the DMA or the Klobuchar antitrust bill seriously, and think that it's possible to create or have a digital economy that is far more decentralized and diverse, and so competition there would be competition by non-incumbents would be possible, then are the same justifications applicable?
Yeah, no, I think it's a great question and totally a fair one. I mean, if someone from DG Comp were here who were part of the case team, or if somebody from, I don't know, Foundum were here, they would say, oh, wait a minute. It's not just about Google and Amazon. There are a lot of us here, and these aren't just like kind of imagined firms that we hope to emerge. Like, these are actual firms who might well be regarded as kind of collateral damage in this giant against giant warfare that I'm imagining in that part of my remarks. I think that's right. I think that critique is a fair one. And so I think I have to concede that I would be accepting some collateral damage in the interest of promoting this other form of competition. Might not even be our favorite kind of competition. And so, how do we make further progress on this, right? We might resort to some kind of ideology like, I don't know, I think it's always competition at the merits that matters. Or I've spent 10 years at AT&T and I really believe that Ma Bell style innovation is the way forward. We might be able to try to get empirical traction in particular specific examples. I'm honestly not really sure. My gut, I'm not deeply steeped in the details of comparison shopping engines and Google and Amazon and shopping starts. And so there's probably somebody better than me to try to work out what's the best hope for competition against Amazon and shopping starts. I've seen a lot of things not work though. And so my gut is that it's hard. And so I'm scrambling for scraps. If you're scraps of intelligence on how to make headway. If your view is that Foundum, for example, was going to be extremely successful, but for Google's rearrangement of shopping results, then you should very much dislike my take, I think. My own take on that is that the CSEs were not super potent, that they were kind of sitting in the shadow of what Google was doing, and that the modification of results was, yeah, bad for Foundum, but in the scheme of things for consumers, not a big deal, contrary to what Foundum would probably say. right? And maybe irrelevant to how DG Comp would think about the case ultimately. My own intuition is that, although not that successful in their own effort, that Google was a good shot at taking on Amazon in this way. And so that kind of context-specific intuition is part of what's governing this. And how would this get operationalized in practice? I guess what I would imagine is that apart from can we win this case, there would also be a view as to whether in the exercise of prosecutorial discretion, either we're not going to bring this one, or that we think this one, though righteous, is not as righteous as this other one. That given the choice between helping the Foundums of the world and helping the Yelps of the world, maybe I'm even more enthusiastic about some other version of a search case, and that the nature of the giant against giant competition should be an input into figuring out which cases we really want to bring. All right, thank you.
Have a great weekend.